So that in this country, we have two instruments of estate planning. One is the wills, the other one is trusts. Wills, most people have some knowledge about wills, but we'll look at in depth what a will is. So starting by, we'll start looking at what a will is. And the Law of Succession Act in Section 3 defines a will as the declaration of a person of his wishes or intention regarding the disposition of his property after death. So one thing to note, that wills will only come into effect after one passes on, and this is one of the simplest instruments of planning your estate. So there are principles behind how to write a will, and the first one is that it should be in writing. And I know many people will ask, how about an oral will? Yes, it is also valid, but given that we know many wills are challenged in court, it would not make sense for you to have an oral will. So better be safe than sorry. So it's recommended that you write your will. And it doesn't mean that if you write your will, then you can't alter it. It's not a permanent, it's not cast on stone. Once you draw up, as often as your life changes, because life is very dynamic, then you can also change the will to align with your wishes. Then the other thing to note is that for when you draw up a will, it has to be witnessed by two independent witnesses. And here, when we talk about independent witnesses, these are people who are not going to benefit in any way from that will. And should you choose to use people as witnesses who are also beneficiaries, then you also have to add two other independent witnesses to witness the two signatures, which makes it a crowd and doesn't make sense. Then you also must get an executor, and preferably a lawyer, because they understand how a will is done and all the intricacies that goes with a will. But it is not mandatory, but advisably, you should have an executor as a lawyer. So after you have drawn a will, what is the process that comes that needs to be followed? So we start by, should you have a will in place? Your executor will then obtain two original copies of that will, two copies of the death certificate, needs to fill a petition form, swear an affidavit, and file the affidavit in court. And if the assets in the will are above 20 million, then that matter has to be filed in a high court. And therein you can see one of the technical challenges, how wills would be challenged on technical grounds. And that is why it is critical that you get a lawyer to be your executor, because they know of such things. So what are some of the challenges? Wills are very formalistic in nature. The decisions that the court might give may not align to your traditions, your practices, your wishes. They're not as flexible because our court system uses precedents. Then the reputational risks should should the will be challenged. Courts are not private rooms, so there's that risk of reputation, the risk that comes with it. And then a court would challenge a will under certain circumstances. And what are some of these circumstances? Number one, if you had a will and you are single, and now you have since gotten married, then a court will vary that will to accommodate your partner because of your status of having gotten married. If you divorce, and please note, this does not apply to if you lose your spouse. If you lose your spouse, the will is still valid. It will not necessarily be varied. But if you remarry after a divorce, then the court will have to vary that will, because your ex-spouse is still alive and there are implications. So the court will definitely vary that will. If a beneficiary dies, of course, it will be varied to cater for redistribution of the portion that was meant to be transitioned to that deceased beneficiary. If an executor dies as well, and you hadn't provided for who should step in in the event of the death of an executor, then the court will also vary it. When you have acquired a lot of assets which you didn't add to the will through an addendum, that will also call for a variation of the will. And instances that would call for rejection of a will would involve allegations such as fraud, coercion, mistake, or unsound mind. And when you look at those 4 reasons when a court would reject a will, if those allegations are proven, those are issues or allegations that can only be proven by close family members, because they're the one who have vested interest. They are privy to a lot of things which would then prove whether it was fraudulently done, whether there was coercion involved, whether there is a mistake, or whether the testator was of unsound mind. So in a nutshell, that is what wills comprise of. So we go to the next instrument, which is a trust. And by definition, it is a duty of care relationship where one party, who is either referred to as the trustor, the grantor, or the settler, gives another party, who is a trustee, the right to hold title or property to manage assets of the third party, who is the beneficiaries. So this is, so to speak, like a safe deposit box where you keep your assets to be managed by somebody else for the sole benefit of the beneficiaries that you have identified. Generally, what a trust would do is collate all the assets that you have put in it and use it to either pay school fees for the beneficiaries, pay upkeep and subsistence allowance, pay rent and accommodation, or hostel fees, medical fees if you have provided for it, and just manage the assets of the family for the benefit of beneficiaries. Then the basic structure of setting it up is that you would have the settler, who's the person who's setting it up. They would document what their vision is, must identify who the beneficiaries are, choose a trustee, and identify all the beneficiaries. And most of the times we confuse, or we believe that beneficiaries is just your spouse and children. That is not the case. Beneficiaries are all those people that you support on a regular. So you will have to identify this, and it may also be charities, organization, it could be institutions. So you'd itemize all of them and how they should benefit from that trust. So why is it important to have a trust anyway? One, it is a good way of ensuring that the minors and the vulnerable are protected. It is also a nice mechanism to ensure that you do not give a lot of money to beneficiaries who do not have capacity to handle money, because we all know youth and money, they don't live in the same house. If one will lose their sanity. So you can imagine if you leave 5-10 million to your son or daughter who's below 30 years, chances of their future having gone down the drain are very high. So in that case, it would be better you use a trust so that their livelihood is met at the level at which they're used to. And as they mature, then you can give them more control. It is also a good way of ensuring that your assets which are not transitioned through a will, which includes life insurance, retirement plans, your cooperative savings, your CBK, CSD accounts, your NSC accounts, instead of appointing a next of kin, you then appoint the trust fund to be the beneficiaries, and that money will be payable into the trust when you pass on, and the money will be used to benefit your beneficiaries in the manner in which you have provided. So in this sense, especially for life insurance, let me speak about married couples who most of the times may not disclose what their worth is, what their life policy is, because of the suspicion that one might get the motivation to kill the other partner. Then you'd cure that problem by ensuring that you nominate the trust fund as your next of kin, so that in the event of your death, that benefit is paid into the trust. So that removes that insecurity that most people have. So that is one of the nice positives about setting up a trust. And yes, many people know about the trusts which have had issues, but that is just because we are wired to buy bad news. Bad news sells. We don't really look for good news, doesn't quite sell.